live right now.
There you go. Good job, Nathan.
Well done.
I have to say that I have a 2-year-old grandson named Nathan, and that's my line. Good job, Nathan. Okay, Representative Stevens, are you with us?
I am, Senator.
Good. I hope you're enjoying our banter here. Good morning to you. I like your shirt and tie. We will get started. You have to be on the floor at some point or back in committee at some point?
At 10.
Oh, okay. Well,
Same with us. So
hopefully we can wrap this up in your part, at least in less than a half hour. So do you want to pull the thing up on the screen or have Nathan pull it up for you?
I guess if you,
or do you want to just give us a narrative to begin with? And then
I kind of just want to give you the narrative. The version on our website that David Hall can make available to you has a lot of color coding in it in terms of what the changes were between the drafts. So that would be pretty instructive. But if you just want a narrative, I can, we, as we always do, we do a long and thoughtful job on our bills, and sometimes it pays off in an 11-0 vote, and sometimes it doesn't. This one passed 8-3 on partisan lines. We had all the Democrats and the one independent vote for it. And I can't speak for why people voted against it. And basically, you sent us S79, which really paralleled H256 for quite a bit of the language, except that which you couldn't get to, which was the revolving loan fund. There was some penalty clauses that you didn't put in. We didn't put those back in. We pretty much, as a base, we pretty much took your bill, did some restructuring of the privacy piece that you put in about where the list was available and who the list was available to. We worked with the attorney on that. We created a couple of exemptions for within the registry for for farmers who provide housing as part of their work contract, not rent, but for the farmers. We heard from farmers that we exempted them for 2 years. And we have a promise from the Farm Bureau to work on farmer housing, farm labor housing that's provided as part of your compensation. It's a dicey field, and farmers, dairy farmers in particular, are don't want another fee or don't want another, to be responsible for the fee, but there's still going to be access to those things. Access to that housing is still going to be required on a health and safety basis as we switch from the Department of Health to the Department of Fire Safety. They're not exempt from the complaint driven. They're just exempt from the registry for 2 years and any fees associated with it. And we also exempted home share situations where there might be a caregiver, where the housing within the house is not generally used for the public, but is used for these home share organizations that happen. And David can walk you through that. We felt that that recommendation came from the Rental Housing Advisory Board after it came over. We also worked on the language. Well, so S79 as you passed it is almost intact. I'd say 90% intact from what you sent us, maybe even a little bit more. And you can see that when you scroll through the color coded version, which is 2.1. 3.1 is what we passed, and that's just the clean version. Then we added the revolving loan fund, which is the $50,000 for people who apply who have a certain income level. And that was something that you didn't have time to get to. So we took our time and got through that and added that on, which was a very important piece in the bill for, I think, for all of us.
And
It's
remind
the
us,
million, so there's VHIP, which is $3 million. And then there's the revolving loan fund, which is $1 million to be built up over years, 5 years or so. That allows $50,000, up to $50,000 to be let out to people who qualify, who are buying a home or who are buying a up to 4 units, provided that they live in one of them. And that's a 0% loan that only gets paid back at the end of, it gets paid back when the house is sold or refinanced.
so this home, this is really an effort for, unlike the other parts of our bill, which is all rental, this is really home ownership, enabling home ownership.
Right, for the same folks of people that we would want to see them to move out of renting if they so desired. And so this provides $50,000, up to $50,000, which would be used, 25% of it could be used for the down payment. The rest of it has to be used for the rehabilitation of the house in order to make it habitable. At the beginning, I mean, when my wife and I bought our house back in 1996, it took us 10 years to build up equity in order to get an equity loan to fix the kitchen, right? And so this is just a program that might allow that to happen, might allow some of these renovations to happen. And these are, and we've been characterizing these as much more as renovations as to gentrification. This isn't flipping a house. This isn't about buying a beat up house, getting government money to make it and flip it. You're still responsible for paying for it. You're probably not going to put in granite countertops if you want to get, a little elitist on it. But it's put in place to help people of I think it's below 120 of area median income, which is the economic demographic that we used for the bond a few years ago, for some of the housing in the bond money. And so it says right in the document, it's intended to assist Vermonters who otherwise may be unable to purchase a home or who may be unable to afford the cost to rehabilitate, weatherize, or otherwise make necessary improvements to a home they purchase.
So where does the $1 million figure come from?
That was a governor's recommend. That's general fund money out of the surplus that was found, if you will, or that came in January, and that's been in the budget going back and forth.
Right. Not concerned so much as to what the source of it. How did the governor proposed $1 million, but is that an ongoing base funding that's gonna? I'm trying to figure out if everybody took out a $50,000 loan, how many homes would you affect? 20?
Well, it'd be 20 in the first. It would be 20 in the first year. The idea is that there will be a commitment. I mean, and of course, every year is different, but there's a commitment to fund this at about a $5 or $6 million level, and over time, just like what we've done with VHFA and the first-time home buyers, closing costs. So there's a commitment there's an implied commitment to fund this over a certain period of time, and so then the money would start paying. It would pay for itself after, or the money that's in the fund would be used to revolve. And we couldn't put aside a set amount for marginalized households, historically marginalized households, Black, Indigenous, or persons of color who have been systematically disenfranchised, because we worked really hard with David about the constitutionality of the language, and because the intent was to lay aside 25% of the money here for marginalized communities, to give them a leg up. So we have language in there that we hope is sound.
Did the question come up as to why not put this extra money into down payment assistance for first-time home owners?
Well, this will include, this money can include assistance, down payment assistance. 25% of any loan that comes out to an individual can be used for down payment assistance.
So my question is, I'm trying to distinguish this program from the first-time home buyers. I mean, one of the things that it seems like there's some overlap. So I'm
The
asking,
first time home buyer program that we were aware of is what's at VHFA,
right?
which provides up to $5,000 for closing costs.
Okay.
And they would work in tandem.
Okay. So
They would not be, they're not tied together, but because this money is going to be going through the homeownership centers and the people who work now with VHFA, the idea is that someone could qualify for that program as well as this program, as well as any weatherization programs that might be available.
Does this envision after 4 years that the money's fully paid back, the loan's fully repaid?
The money would be paid back again if someone refinanced or if they sold their house.
Okay.
And there's language that you worked with Chris Delia to get in on the VHIP program about where the status of the lien is and whatnot. We put that money in as well to make sure that it was clear that, of course, the banks, this is added on to whatever the bank mortgage is. So there's really no question about what the liens are, the liens standing on it. This would just be paid back. I mean, very similar to the way the shared equity program works, is that there's this would come off the top of, if you bought a house for $150, $150,000, unlikely these days, but then took $50,000 of this money, you'd have $200,000 in 5 or 7 years. If the house sells for much more than that, you're still paying back that $50,000. And the rest of it's your equity.
Okay.
Right. Mr. Chair, may I ask a question?
Please.
So Tom, it took, as you will recall, the down payment assistance program many more years for it to become revolving, many more years for people to actually sell their homes than anticipated. $1 million isn't going to go far in terms of it getting to be revolving. Do you envision it being revolving within 4 years? I
believe the idea of funding it at this level is the funding it at this level and then funding it at this level every year would take about, according to Josh, Commissioner Hanford, would take about 5 years. I mean, obviously we set the limits, we can go higher than that whenever we want, but in terms of their estimate was about 5 years. That $5 million would represent homes flip every 6 or 7 years.
really
Even homes at this level.
Even in this income bracket?
Yes. The average somebody owns a home for an average of 6 or 7 years. And before they move up. They might be selling their house to move into a bigger house. They might be, so we were working with that.
So
estimate of time.
You're thinking 5 years, general fund investment, $1 million a year.
Yep.
And when you
somehow,
when you say zero interest loan, you're not talking about a zero interest loan on the commercial mortgage where you might have to pay back principal as you go. People don't have to pay back any principal till they sell their house, right?
Correct.
Okay. Okay. Where is the bill at this point in the House process?
It's in Ways and Means.
Okay.
I'm meeting with them tomorrow.
Okay. What can you predict the future on this with any kind of likelihood at this point?
The money is, we are tracking down the $400,000, which is, it's not 200 anymore. It's 300 to DHCD and 100 to Department of Fire Safety.
We've got
And
it.
we think we found it.
I think we're set. I mean,
Yeah.
I've been working on this.
We have it on the Senate side anyhow.
We're
But-
fine.
Yeah, I think we're fine with the money. So it just has to go through Ways and Means and Appropriations. And I have an understanding, though, I'm not gonna have it written in stone, but that we should be on the floor early next week with this, is the hope. I'm not quite done with the walkthrough on the bill because there's one section that you didn't consider in it. Is that, can we move forward to that? Or do we have?
I just want to respond to one part just so we can flag this early on. The whole home ownership piece is pretty new to us.
Yeah.
I don't think we have any, I don't think our appropriators know any, well, maybe they know through your appropriators, but they don't know through us to have set aside money, that $1 million for us. Though somehow they set aside $5 million for VHIP. So I think they were sort of accumulating a lot of different monies in there. So,
Yep. You know, as you know, we handle money differently. And of course, out of the policy committees, I rarely get an opportunity to hear the words, you know, yes, you should spend money. It's always just policy coming out of us. And so I suspect that our appropriations committee will give an accurate, to their knowledge,
right.
an accurate appropriation on this. And then because the bill is already in conference, I would imagine they'd be having that conversation with the Senate.
Okay.
So Mr. Chair, and Tom, does that account for the 5 million that we're seeing in the budget for VHIP as opposed to the 3 million? Is that where that extra million is? And
no, if I'm not the $5 million, is that coming out of the general fund or ARPA funds?
I think it's coming out of ARPA funds, but
that's the difference with this right now. And I think that's what's going to get settled in conference is because this called for the money to come out of the general fund. And we have the $4 million I've been told out of the general fund is set aside and is in our budget for this. That $5 million for VHIP through ARPA, appropriations may be turning around and saying, well, if there's 5 million in ARPA that we can use for the VHIP program, then maybe we pull the 3 million. I don't know what the negotiations are going to be. I do not think you can use ARPA money for the revolving loan.
Right. I don't either. So that's why I was curious. So I looped Stephanie Barrett and Mary Hooper. Everybody's on the same page about the 400,000. So I think we're in pretty good shape. I'll forward that to you.
okay,
Yeah,
so
I imagine I'll touch base with appropriations this week as well. I mean, I'm hoping that that Ways and Means doesn't have a problem with the fee. It shouldn't. I mean, it's a reasonable fee, but that's just part of our process. So,
okay, let's hear the missing piece.
yeah. So the last piece that we got in was some changes to the eviction moratorium.
Right.
I don't know about you, but we've received, of course, dozens of emails from irate property owners about abuse of the eviction moratorium by tenants. As you also know, we always try to retain a balance between landlord-tenant relations, and I think we did a really good job with the eviction moratorium, and they've been working well together. The federal money in December threw things a little out of whack because of the way that it operated differently than the coronavirus relief fund, and landlords and all of those programs. With the testimony we took from Richard Williams' shop, from the State Housing Authority and others is that the payment programs that were put in place with the CRF were really successful.
Yes.
And, over 90% of the people, or about 90% of the people who were involved in the application process found some satisfaction at some level, which is remarkable and really good to hear. However, as always, there's going to be 10% of people who are upset. And so this, through some really lengthy discussion and negotiations with legal aid and with the landlord association, we adjusted and not knowing how long the emergency period is going to last, right? People are making assumptions that the emergency period is going to end on July 1. I'm not so certain of that, but that's out of our hands, right? We don't know for sure. And so we didn't want to do something that was off the cuff and really open the door to evictions that people wanted to make because of personality differences. What this does, what these adjustments to the eviction moratorium do, which again, all of this gets rescinded when 30 days after the emergency period is over, and we go back to what's in statute. So this still remains temporary. And what we're doing is allowing for an emergency hearing for ejectment to happen through the rule of civil procedure process. What we added in was that if the landlord needed to occupy the rental premises, if the tenant is not participating or does not qualify for the Vermont Emergency Rental Assistance Program, which was something that was in the federal moratorium.
Sorry, can you say that one again? Sorry, I was stuck on if the landlord needed to move back in. So that's
If
one.
the tenant is not participating or does not qualify for the Vermont Emergency Rental Assistance Program, what we heard was that there were people who just refused to pay rent, even though in the moratorium, does not give a rent vacation. It's very clear about that, but there were also claims that we heard from property owners that I know that person can pay rent. I know they can afford it. They're still working and they're choosing not to. And landlords haven't been able to approach some tenants in order to work with them in order to pay back rent. And of course, once you pay back rent, any eviction proceedings would end. And then we added a phrase that gave the property owner the opportunity to ask for an emergency hearing if the tenant was tampering or disabling a smoke or carbon monoxide detector. Just in terms, again, we were responding to things that we heard through emails, and that people were destruction of property. And the courts. I'm sorry.
That already as one of the reasons that is one of the
a lot of us think that the eviction moratorium does cover that. People want it to be more precise. It was a long negotiation. But the important thing to remember is that none of this language, in our interpretation of it, overtly allows immediate eviction. It merely opens up the process, which is important. It opens up the court process. It instructs the courts that they have to have these hearings.
Let me ask you a question on that, because my understanding is the courts are still very slow in opening up, and they had their own guardrails about people coming in for landlord-tenant situations. You're not trying to override the courts and tell them what they can hear and what they can't hear at this point?
I think we're clarifying what we heard from both the courts and from people who were trying to work on these cases into the court system is that the courts took a very hands-off, even when, again, we don't see all the claims. We just took the testimony and heard from individual property owners where they testified, and the court agreed that there were times where they felt that they could not allow an eviction proceeding to continue based on the broadness of the eviction moratorium in places,
Right.
but also because of the fact that they're limited as well.
Ask a
So
question,
my
Mr. Chair.
my question for you is, are the courts still maintaining their limitations to only having court hearings in emergency situations, or has that changed?
With respect to housing,
Yep.
I believe it's still just on an emergency basis that they are, you are allowed to start an eviction proceeding. It just doesn't get served. And that only would get changed here under an emergency basis. And we feel this is a little bit clearer than what was in place.
Okay.
But it's still just under an emergency standard. We put the using the federal money. We put the rent arrearage programs in place again because 80% or more of eviction cases have to do with back rent and nothing else. And we're hoping that the $110 million that's in the system right now for rental arrearages gets this, that's all money that would go directly to property owners, to landlords. It's for a singular purpose, and hopefully that would keep the eviction proceedings down.
Chair, may I ask a question quickly?
Yes.
One of the issues that I've heard a great deal about is people who say they have tenants who simply refuse to sign the forms necessary for the landlord to be able to get rent. Has that changed?
Because the current program had tighter guardrails from the federal government, the change has to come from the federal government. The rules have to change at the federal level for us to be able to do that. To copy what we did with the coronavirus relief money, which was much more lenient in its guardrails. So I know that the administration and the stakeholders are working with the federal delegation to try to change that. In the meantime, what we did here was, if there's a case where the tenant's not signing the paper and is choosing not to work with the tenant or work with the landlord, that a landlord can now, under this proposal, would be able to use that as an emergency application.
Okay.
Again, it's no guarantee. It just would open the door.
Okay. Good. Thank you very much, Tom. Does anybody else have any questions for Representative Stevens at this point? What we're going to do, I know Senator Brock has to leave for a half hour. We'll move on to David Hall to give us about a 15-minute walkthrough so this stays fresh in our mind, and then we'll move on to home contractors.
Okay.
Thank you.
And thank you guys for your work on S79 to come over. It was I know it was hard for you guys to get it across in terms of time, but I'm glad you did.
Thanks.
Good work.
Senator Clarkson to thank for that.
Oh,
Okay.
All right. Thank you.
Bye-bye.
bye.
David, good morning.
Good morning, Senators.
Good
So
morning.
what I'd like to do is spend about 15 minutes more on this and just walk through the bill with focusing mostly on the highlighted changes from where they are now versus what we passed. Is that something
Sure.
we could do?
Happy to do that.
Okay.
Shall I share my screen or do you want me to just guide you page to page?
Share your screen.
Do you have it on, is it on our website?
I don't know, but I have sent it to the committee. I believe Nathan is included on those emails. So if the chair would like it to be posted now, please feel free.
Yes, please go ahead.
It's posted.
Oh, great. Thank you, Nathan.
Nathan is 3 steps ahead of me.
He is a whiz.
All right. So for your record, David Hall, Legislative Counsel, this is the Senate Bill S79 Act relating to improving rental housing health and safety. And what is on your screen, what I'm discussing, excuse me, is labeled as version 2. And I want to say again very clearly that this is the version that House General passed out of its committee. The version 3 is clean copy, no highlights, but this is that with the changes relative to the Senate language.
So I'm sorry, I hate to, oh, okay. So it's the last of the 3 options. It's as passed by House General, as opposed to 3.1. Which one do you want us to look at?
You should be looking, let's look at 2.1 right now.
Is that the one that's labeled as passed by House General?
Yes.
I think, I don't know the labeling, to be honest.
Well, I'm
Okay,
looking
yes,
at,
it
I'm
is.
looking at, I only
It's
see
2.1.
3.1 on our page. So,
Yeah, the 2.1 is the one at the bottom.
okay,
As it says, as passed by House General.
okay.
Yeah, I apologize if this is causing any confusion. I think it's really, it was critical to hold on to a highlighted version because obviously at this late stage in the session, everybody wants to know what's different, right?
Yeah,
So
no, that's good.
again, 3.1 is the clean version voted out by House General. 2.1 is that version with various colors of highlighting
Okay.
to show you the
So
differences between.
so let me
housing.
just say, let me just ask David to walk us through and for people to hold their questions until he's done. So we can make sure we get through the whole thing in 15 minutes. Okay.
Sure.
Thank you.
I'm gonna jump. Just you'll recognize that you're making changes here to the Department of Public Safety's authority to include rental housing, health and safety. The change here is minor. It's just the way we cross-reference what is included, but substantively it's the same. It is this authority applies to housing that is leased or offered for lease and includes dwelling units as we define it in the landlord tenant law and short-term rentals as we define it in Title 18. The change here is relates to the applicability of the commissioner's authority to adopt rules, and they're striking from fire because the scope of the authority is broader than fire at this point. It's not just it's even without this bill, from fire arguably may be too limited because they do more than just fire at this point, as that chapter has expanded over time. This is just a one-word change from investigation to inspection to be consistent with the rest of the language. This change is a little bit different, and you may want to hear about it. So you may remember that you have a provision right now that applies to local health officers, and when they conduct an investigation, they need to produce a report, right? And you have grafted that requirement onto DPS here rather than local health officials because now DPS would be primary. The change that the House made in yellow, though, is to say that when they conduct an inspection and issue a report, if it affects the entire building, they have to give the notice of inspection directly to all of the tenants and may post it in a common area. And that is different. You had adopted language that just said if it affects the whole building, they shall post it in a common area. And there was some debate about whether or not, DPS could send an individual notice to every tenant in a building, particularly a large building. But in the end, the House decided they wanted direct notice to tenants if a whole building was affected. And so that's the change they made there. That is probably, I think, I mean, this is a very minor language change just to make sure that when there is an order to rehabilitate or remove a building, if it will affect people who would be displaced, then they have to get notice of the order. And I think substantively it's the same idea you guys had. It's just a slight change to the wording, which clarifies that they want it to go both to holders of record and to people who are not holders of record but would be displaced. So that's it for DPS. The next piece comes to the registry itself. The changes here, B1 and 2, are to reflect that they want to collect contact information about owners, landlords, and property managers to the extent those are applicable in any given situation. So that it's a slight expansion. We have name and mailing address in 1, and then phone number, email address in 2. Those are separated out because while most people have a name and a mailing address, not everybody has a phone number or an email. But the real substantive addition here is to ask for that contact information from landlords and property managers to the extent those are different from the owner of the building. Representative Stevens mentioned this. It's a rewrite of the data confidentiality piece after some discussion. So conceptually, it's very similar. In D1, it uses more standardized language to say that the registry and the registry data are not public records, so they are exempt from public inspection and copying. And it says that the department shall not disclose the data except as provided in subdivision 2. And as you can imagine, there's a lot of discussion in subdivision 2 about the circumstances under which they can disclose the data. You may remember that when it left your committee, you basically said if it was for the public good or for people that the department say can have it. And that was too broad for the House committee. They narrowed this to say it may disclose data to state, municipal, other regional government entities, nonprofits, or other persons to protect public health and safety. And there was some discussion about whether that's too narrow, but this is where they landed. And then B, they shall not disclose the data for a commercial purpose. And C, they have to ensure that the person doesn't further disclose it and take steps to protect the information. So that's a little bit different from yours. Here in the registration requirements, there are some exceptions to registration. So number 2 here, the blue, is basically the operative piece is housing provided to another person if and only to the extent the housing is not available to the general public. And that was meant to capture things like home share and family members and friends and personal care providers, where the unit is not actually rented out to the public, it's provided to other people and not basically advertised or offered for lease. If the unit is offered to the public, even for a month or 2 months, then it becomes subject to the requirement and would still have to be registered. So 3 is the owner of housing provided as a benefit of farm employment. And that's a term that is defined in the landlord tenant law. Specifically applies to housing that is part of your compensation package. It has slightly different rules, particularly for ejectment actions. So we can talk about that in more detail, but again, Representative Stevens mentioned that. They added sort of a 15-day grace period for late registrations. So the fees would apply after that. This is the sunset for the housing provided as a benefit of farm employment. So in 2 years, that will sunset. They went with your construct, the Senate construct on the positions and the appropriations, except that they shifted the money around. So 100 would go to DPS and 300 would go to DHCD rather than 2 and 2. Trying to zip through. We don't need to worry about local health officials. The transition provisions are all the same. VHIP, there are just a few changes. They took out the mandatory weatherization component because they want it to be part possibility, but not a requirement in case it doesn't need it or it's not a good use of the money. There's a restructuring change here so that the two VHIP possibilities, the properties could be either non-code compliant or a newly created accessory dwelling. They took out the vacancy piece because the way that that had shaped up was that, you know, they were saying it has to be vacant because it's not code compliant. And then that became obvious that, you know, if it's not code compliant, then it doesn't matter if it's vacant, it already qualifies. And vacancy for its own sake is not a reason to give people money. It could just be uninhabited for an amount of time. We want to fix places that are broken. So they shrunk that down to be either not code compliant or creating a new dwelling unit. Again, may include weatherization, but the program requirements are, you know, they're the same. Same for the forgivable loans and the, you know, the requirements. Same for the lien priorities. There'll be a report specific to VHIP, and then we have the home ownership revolving loan fund. Obviously, this entire thing is new. I mean, you guys didn't have this in your bill, so we'll have to go through that in more detail.
So, sorry, David, did you miss have you just not gotten to, what page are you on? Because there's the whole outreach section too that's new. Oh, you haven't gotten there yet. Yep, sorry.
The outreach section is in the revolving loan funds.
Yep, sorry. Start section 12. Got it.
And that obviously, again, that whole program is new to the bill. So when we have more time, we can take a look at that.
Good idea.
And I believe that's it for this bill right now, again, does have $4 million in live general fund appropriations. This bill has not been to House appropriations. I do not know what will happen there. I do not know what's the status situation in the budget. The eviction moratorium piece, Representative Stevens mentioned, creates basically a new subsection that deals specifically with actions for ejectment on an emergency basis and attempts to spell out in more detail what the legislature considers to be emergency circumstances that would authorize the court to move ahead with an ejectment action. Remember that everything from motions to writs of possession to orders are all frozen because of the moratorium. So this says, notwithstanding that, if you have emergency circumstances, those actions can move forward. Here's what we consider to be emergency circumstances in more detail. And if the green language here, if a plaintiff asserts facts in an affidavit that are sufficient to raise the concern or the possibility of emergency circumstances, then the court will have the authority to move forward by issuing necessary preliminary orders, scheduling a hearing, authorizing service of process, and then after holding a hearing, issue any necessary orders, which may include a writ of possession. So it's not telling the court, it's sort of freeing the court from the restrictions of the eviction moratorium in emergency circumstances and trying to put some more shape on what those circumstances are.
Okay, so we're going to have to move on. I'm going to use chair privilege here to ask one question, and if other people have questions, they can certainly ask it. I'm still not clear on the eviction moratorium, whether we're just clarifying what we allow as an emergency in our moratorium law, but I didn't think our moratorium law, the old one or as amended here, govern what the court would consider an emergency circumstances as to them having the resources to have emergency hearings. Are we telling the court that in these circumstances, you have to hold an emergency eviction hearing?
No, in the sense that, are we telling them every time they have to? No, you're telling them that if a plaintiff comes to you and it looks like what they've alleged in their affidavit is an emergency, then you have the authority to move forward. The reason I think that this adds more language to what's in the current act is because the court had been reading it very narrowly. You know, your underlying law said that it was not intended to foreclose the court's ability under AO 49 to move ahead with an emergency. And that would include an action that involves criminal activity, illegal drug activity, or acts of violence, or other circumstances that seriously threaten health or safety of residents. The court just kind of stopped there. So rather than exercising its, inherent authority to consider other things that might be emergencies, which it did have the right to do and still has the right to do, the court looked at that law and said, these are the only things that really count as an emergency as far as we can tell.
Okay.
That's my understanding. The court took that narrow of an approach. And so we're trying to broaden the scope in the statute so that it will take a broader approach when it considers what an emergency is.
Got it.
Thank you.
Anybody else have any questions for David at this point? We'll definitely be getting back to this bill. But we have a bunch of witnesses on the other bill, and I want to get through those today. Okay. Good. Thank you, David. You're with us on the next one as well, right?
Yeah, I'm just hanging around.
Okay, great. So I know we have Chris West and Matt Coda. Why don't we start with Chris? I assume, Chris, you were around for the last hearing, right? And you heard everything. So why don't you, the floor is yours. Take it
Thank you
away.
very much.
Welcome.
Thank you. Thank you for the opportunity to speak to you all. Good morning, senators. My name is Chris West. I've been living in Vermont since 2010, moved here after 10 years of living in the Netherlands with my Dutch wife, raising children. I'm originally from New York City, grew up and raised in the theater in New York City. My father was a Broadway electrician. I have a BS in mechanical engineering from the Technical College of Amsterdam. I'm an ex-president of the VBRA, and that's the Vermont Home Builders, and a current executive committee member. I'm a certified passive house consultant. I've been doing that for about 11 years now. Passive house is a super insulated type of building where we're looking at building durability, but also getting the loads and things down, looking at building science of it all. And I also train people who do that. I'm a founding member of the Vermont Passive House Association. I've been doing building audits in conjunction with my colleague Jim Bradley for the past 9 years. So I've been in hundreds and hundreds of Vermont houses. I'm a member of various state boards, including the RB's advisory board, where we look at the next versions of RB's. And I have a radio show that I started last year on WDEV, where my colleague Jim Bradley and I take phone calls from people about building science questions about renovations, how you can have a good idea to do to your house and completely mess it up. And one of the things that Jim and I have noticed through our years of working in the field is we're regularly running into people who are the victims of low and level and high levels of misuse by building professionals. That has caused us to be very big supporters of this bill, the H-157, in all of its iterations. It is, I don't know if you know the history, but the history of the registry started in 2008 when Ward Smith, owner of Turtle Creek Builders in Waitsfield, and a number of other members of the VBRA set up or working to set up a private registry, because they understood that we had a real need to increase the professionalism of the building trades here in the state. That was kind of blueprint that we used as we've been going around trying to get legislative passed in this. Probably heard a number of these points before, but I'll just run through them. A house.
Can I interrupt for a second?
Absolutely.
The home builders, are you speaking on behalf of the Home Builders Association?
I am a person who works with the home builders, and I am involved in their work. I am speaking as a private business owner in
Okay.
my capacity here.
Okay.
But I don't want it to be over. Don't want people to say, "Oh, Chris, he's also with the home builders." I don't want that to be lost in the discussion. But I am speaking about my own personal experience.
Go
in the
ahead.
field. Thank you. A house is the most expensive thing that most people will buy, and when someone goes in to buy a home, they have absolutely no knowledge of what makes a good home. They may know what they like, the look of it, they like where the windows are at, they like the view, they like the fixtures, they like the fact that they can't see any appreciable damage, but they have no understanding of the building science behind how a building operates, this building as a system, as we call it, and how certain choices that a builder might make or a renovator might make can take a house that either was okay and make it worse, or build a house to start with that just has durability, health, and safety issues into the future. And they look to the builder to be the adult in the room, to be the expert on these things. And right now, the current framework, the state doesn't have a list of people who are builders in the state. The current state framework doesn't require anyone to have any education to become a builder. All of us in this room right now could go to the Secretary of State website, pay our $50 and start a building company today and start building tomorrow. Without necessarily having insurance and without necessarily having any kind of training. That's kind of the framework that we're living in. The bill that we're talking about doesn't require that you have that training, but it does require that you have the minimum insurance, and that with a $3,500 or larger job, that you have a contract that spells out protections both for the consumer and for the builder, because of course, as builders, we all know that there are difficult clients sometimes. I have traveled around a lot. I've been in New Hampshire. There's a company called Preferred Building Systems. And when I was there a number of years ago, and I spoke to them about, finding a builder in Vermont, because they build high performance modular systems that they then need a builder on site to put together. They say, yeah, well, here in New Hampshire, we call Vermont the Wild West, because there is requirement to become a builder. There's no licensure. Not that we're pushing for licensure or that I want licensure, but they consider it hard to find people on a regular basis who they think are up to a high standard, because it's such an open field. When you're building or renovating a house wrong, it can be just as dangerous as a faulty electrical or plumbing work. A wall full of black mold can be just as bad. It can create rot. We're investing a lot of money into these buildings, and we want to make sure that the people who are building these buildings have at least a list that we can go to and say, by the way, did you know that you should know these 4 things? The basic Arby's code is another problem. We don't know, the state doesn't know who we need to contact when we have a change in the Arby's code, which is every 3 years.
So Chris, you're probably one of our best witnesses for on the ground experiences here. I'm trying to understand, in terms of registration, we hear repeatedly that this bill doesn't necessarily cover poor workmanship. So you build something defective, mold develops unnecessarily. What does this bill do for a situation like that? And a corollary question to that, have you seen, I assume that insurance might cover that situation. And I'm assuming that there are many builders out there, even though we are the Wild West at this point, and there's no even registration, that buy insurance. Have you seen insurance pay out in situations of poor workmanship?
Yeah, so those are both very, very good questions. And the first question is, this registry would not stop the first offense of someone doing something poorly. But what it would do is create a framework where a victim of poor workmanship, whether it's done on purpose, nefariously, or done just because they don't know what they're doing, that the owner of the building would have recourse to go and say, this happened. I have a complaint. This person did not follow Arby's code, did not do the due diligence, and therefore the second victim would be protected, because that person, if they were found to have been guilty, would be off the registry and should not be operating as a builder. So that's the protection.
I'm not sure of that. I mean, I would ask our counsel whether that's the case, because we keep hearing that this does not necessarily, you don't lose your registration because of poor workmanship. So,
Well, then maybe this bill doesn't go far enough in that particular direction. However, my experience on the other side is that I've been involved with 3 cases, not personally, but my colleague Jim Bradley, who is a BPI certified building analyst, has been involved in 3 cases in the past 9 years that we've been working together, where an owner felt that, and right with our observation and analysis, felt that the builder had not followed the residential building energy standard, or had done things that were obviously counter to good building science. And the lawyers say that unless you have a minimum of $100,000 worth of damage that you can claim, it's not even worth filing. So there's a huge barrier. The only enforcement for Arby's at this point, or any of these other types of regulations, is suing. And what we have found is that it almost never works out for the owner. These lawsuits take 5-6 years, and they end up having huge legal bills that never ended up covering the final cost of the repair to the building. So in that situation, our experience is that most people, unless they have that level of damage, just eat it, and they accept that as an unfortunate loss that they have to deal with.
I guess what I'm trying to get at is, on the insurance side, having done a bunch of small claims early on in my career, one of the things you want to find out immediately is whether there's any insurance coverage, so you don't have to try and litigate. And so if a builder, a reputable builder, or a home builder, or a handyman, whatever, pays this $600 for insurance, I'm asking, have you seen situations where they say, oh yeah, I screwed up, contact my insurance company, the insurance company pays the claim for poor workmanship?
So I have not seen that, and most of the reasons is because most of the insurances that are required, including the one in this bill, by the way, is general liability insurance, and that is not professional misconduct insurance. I have a separate insurance myself, which covers professional issues, where if I were to, advise someone to build a certain way, and they were billed that way, and it ends up turning into a horrible mold fest, and they have to have it redone, that's the insurance. General liability insurance is if I'm on your property and my worker backs up and hits your fountain, then they can go to that for that. But I don't think it covers.
Yeah, I'm starting to fear that we sort of maybe missed our mark on the kind of insurance we want to have. On the other hand, I think if we had professional responsibility insurance, is going to be much more expensive.
Yeah. So my general liability insurance a year is about $600. And
well, liability is cheap.
Yeah. My professional liability insurance is about $1,500. So it's not, it is more, but it's not an order of magnitude of 10 or 20 times.
Okay.
Well, and protects people from a much larger possible claim.
Yeah,
absolutely. Much more frequent, certainly, for sure.
And we're concerned with getting basic good business practices in place first. We need a framework to start with, where at least the people who are out there who are working have general liability insurance and have a contract for those things. And we understand we're also fighting a perception of governmental overreach with this. A lot of people, most of the main arguments against this are that we're putting in, the slippery slope is the grand argument there. And we just like to get the toe in the door. We just like to get a list of people so that when Arby's updates, we can have the list. We were contacted by the Department of Health. The president of the VBRA was contacted a couple of months ago by the Department of Health saying, do you have a list of the builders in the state? Because we need to get them this important information. We said, we can get it to our members and we can put it out to the people we know, but no, we don't have a list of people who are doing this work in the state because the state doesn't require that. And that's a concern as well. But so maybe you're right. Maybe this particular type of insurance is not the type that would protect against a bad build, but it would at least give us a way of approaching someone who is a builder who was doing damage in the field and say, look, you should not be doing this. Maybe if in your contract it says that you're going to be building something of a certain quality and ends up not being that quality, maybe
it might. I don't know. I guess it would depend how the contract is written. It might cover like someone who builds a defective deck and then somebody trips and falls on it.
Or the decks, my friend Jim always says more people are hurt on decks than any other part of any house. It's the number one place where things fall apart, as it were. But yes, I see what you're saying.
Okay, well, does you have more?
Just a little bit more, right? So the reason that we're behind this registry and that I'm behind this registry, because it is a light touch. We're not trying to create a licensure. We're not trying to create too many more layers of administration on top of this. But we also think that if your hairdresser has to be licensed to touch your head, then we should at least ask that the people who are building this most expensive part of our infrastructure, and by the way, very importantly, every time a private house is built, that increases the actual infrastructure of the state. And if we're making good infrastructure, if we're making infrastructure that comports at least to the residential building energy standard, which by the way is the worst house that you can build and not be breaking the law, right? The code is not a great house. A great house is something like a passive house, but it's okay, right? And if they're building worse than that, then those people should not be operating. They should be told why. There should be a list. We should be able to approach them and say, look, we understand that you learned how to build back then, and back then that worked, but now we're making our houses tighter, which means that moisture is getting trapped more readily. We have to really think about how we're building our assemblies in these climates that we live in. This wet and cold climate is very rough on houses when you start making them very tight. So we need to be able to have a list of people that we can go to and say, did you know this? Here are some classes. You don't have to take them, but we think it would be a good idea. And also so that the state can get access to people as well. So those are the points I wanted to bring up. Thank you so much for the opportunity to speak to you. And I'd be happy to answer any further questions now or in the future.
Thank you very much.
Chris, have you submitted a written testimony to us as well?
I have not submitted this as written testimony in the past, but I do have it available and I can make it available to you.
That would be helpful. Thanks.
Okay, sure. I'd be happy to do that.
Okay. Thank you. We're going to
Yes,
move
you're
on
very
to
welcome.
Matt Coda.
Thank you so much. You all have a good rest of your day.
You too.
Yeah. Are you going to stick around for questions after? Okay, great.
Yes, I'll stay until you're done.
Matt, welcome.
Thank you.
I don't know exactly your take on this, but listening to Lauren last week, I'm feeling like you're asking for some sort of exemption from the bill. So with that stage set.
3 words, that's all.
Oh,
Okay.
just 3 little words.
3 little words.
Okay.
Senator
Go ahead.
Sorokin, Senator, members of the committee, thank you very much for allowing me to testify. For the record, my name is Matt Coda. I'm Executive Director of the Vermont Fuel Dealers Association, which is a nonprofit trade organization of businesses in the energy and the energy services industry. As some of you know, we provide legislative and regulatory assistance for our members. We also provide training, safety, and education programs that are required in Vermont for certification and licensure. We in fact train more than 1,000 Vermonters every year: plumbers, electricians, oil heat techs, natural gas technicians, propane technicians, as well as propane, oil heat, gasoline, and diesel delivery drivers. We do that out of our office in Berlin. We work with high school tech centers and organizations like Vets to Techs and Vermont Works for Women to provide a pathway for employment for individuals who want to seek a career in the skilled trades, a lucrative, fulfilling career in the skilled trades. And in compliance with the law passed in 2020 that we worked on with Senator Clarkson, thank you, Senator Clarkson, and Senator Ash, classes teach Vermont's energy efficiency and renewable energy goals. So that's what I do when I'm not testifying and not running city council. I sympathize with Chris and others in the construction industry who want a registry. You want to establish a standard and accountability. But when it comes to the heating industry, we are the opposite of the Wild West. We're the stable East. We were sitting where Chris is sitting 25 years ago when we advocated for the creation of a certification standard for heating technicians. Today, there are over 10,000 licensed and certified individuals on the Department of Fire Safety licensing master list that's found on our registry, data.vermont.gov. I encourage you to look it up. It's for this reason we ask you to strike 3 words from H157, plumbing, electrical, and heating. First, the confusion. It appears that we have an exemption, right? It states right in the bill that there's an exemption for anyone licensed by the Department of Fire Safety, Division of Public Safety, Department of Public Safety. It's a little confusing for a couple of reasons. One is the language in the bill says those that are licensed by DFS are exempt. Well, in the oil, heat, propane, and natural gas world, it's a certification standard maintained by DFS, in which you have to apply for a certification, pay $60, prove that you don't owe back taxes or child support, get 8 hours of continuing education after you've done your initial qualifying classes and gone through the apprenticeship program, and then at that point you get on the list. But it doesn't say certification; it says licensure. So that's part of the confusion. But the bigger part, that's a small issue. The bigger issue is that this bill exempts individuals, those licensed by Division of Fire Safety, but not businesses. So let me play this out. So Matt, the plumber, if I own my own van and my own toolbox, and I go and work on your propane equipment in your basement, I'm exempt and don't have to be on the registry. But if my mother Sue owns the business and pays me to go into your basement and work on your propane equipment, she would have to register. That's going to create some confusion over who should be on this list and who should not be on this list. But you could solve that, presumably. It just makes more sense to have it over at the Division of Fire Safety, which controls our licenses and certifications. But that's another issue. The bigger problem I have, which you don't have with the people that are trying to fix the deck or the roof or the or build an addition that Chris has, is that this registry for the plumbing, heating, electrical sector creates a false impression that the people that paid $250 to get on the list are actually trained to do the work, when in fact they're not. In order to become a plumber, electrician, a gas tech, or an oil tech, you need significant training and education, and you need a license. But if I have $250 and I can get on this list and say I'm a plumber, say I'm a gas tech, and we have people that aren't trained, that the common person who might look it up, well, I want to hire someone on the registry, and then find out, or not find out until it's too late, that the person that they've had to put in their basement to work with hazardous materials, combustion, carbon monoxide, is in fact not licensed at all. Having a registry to make sure that companies have licensed employees is important. I'd happily work with this committee, with OPR, with the Department of Fire Safety on such a thing. This is not this bill for us. We ask that you remove plumbing, electrical, and heating from the bill.
This is, I mean, I guess we need to hear from Lauren, because this seems like a no-brainer to me. I mean, I guess I would have thought that the paragraph above, I don't have the bill in front of me, but would have said licensed or certified. That would that would cover your folks, and then the section below could say electric plumber not otherwise certified. It seems like that's what we're after achieving. I don't know what the problem is here, but we'll find out. What did you raise this in the House?
Yeah, that was my question is, what happened?
And
So-
yeah, did you raise this in the House? And I guess we'll actually obviously have to talk to Lauren, because I'm surprised there's not an easy fix here. But go ahead, see if you can explain that away if you can.
So I had a conversation in the wrong committee. That's my fault. I had a conversation in Ways and Means Committee with that committee, where I should have started earlier. Perhaps part of the reason is my own confusion, someone who's been doing this for 15 years, about thinking that we were exempt. And then after staring at the language for a while, realizing that in fact we're not exempt, because it exempts individual owner operators, but not companies. So Casicchio's Plumbing and Heating.
Wouldn't it have to be a company that uses somebody from the Wild West? Essentially, I mean, if they use all certified people, then there's no reason to ask them to register. If they don't, then there is a reason to have them register.
So it is my contention that is not clear in the law.
Okay.
That in the law, it only says those individuals do not have to register. But of course, there's the population of individuals that are owner operators is small in comparison to companies that hire licensed individuals. It's companies that are registering, or individuals that are their own owner operators that are registering. So if big giant plumbing company, the person that would have to register, or the company that would register, may not be licensed. Or in my example, my mother owns a company, but she's not a plumber, but she hires me because I am. I wouldn't have to register, but the company would.
But if she's not doing the work and she's hiring somebody to do the work, I thought all this bill was trying to do is to make sure the person she hires is registered or certified or licensed, one of the three. I mean, if your mother's doing the books on a company, why do we care whether she's a registered electrician or something like that?
Exactly. But this is all about contracts. So when you sign a contract, the plumber or the heating technician is not the one signing the contract. It's the company, it's the business manager, it's the service manager, it's my mother that's doing the contract, not the guy in the basement with the boots and the wrench.
I don't need your mother to be registered unless she's using unregistered workers.
So there's two ways that we could solve this, is by clarifying that companies that have licensed or certified individuals in their employ are not to register. But then you've got this separate dynamic, right? Where you have individuals who are not licensed to work on gas equipment or oil equipment or plumbing or electrical, who do have to register, but are not qualified or licensed to do the work. But they pay $250 to be on the registry.
Well, I mean, that's a problem, that they shouldn't be doing the work just by virtue of the registration, because they still have to get certified under Vermont law. Right?
Right. But if I don't have any training in gas work, I can pay $250 because there's no certification standard, get on this registry, point to any potential customers and saying, look, I'm registered with the state of Vermont. I have insurance, general liability insurance. You can hire me. And then the customer not know that, in fact, I have no license or certification in order to work on this equipment. We're not talking about decks or roofs. We're talking about people that are going into your basement and working with combustion equipment.
I'm starting to see Lauren's concern here, but I think it's fixable. We don't want people to use this registration as a way to avoid certification, or as a way to get business without getting certification
or licensure.
Or licensure that we have under
licensure where it's required.
I can't believe there's not a way to fix this. I don't know if Lauren is with us. Is she?
She's not.
Okay.
I mean, she's not
Right, today. Okay.
right here.
So we'll have her listen to this, and I would strongly suggest that you continue to talk to her. I assume you have been, and we get to an agreement here that meets at least the committee's needs.
Well, and the reason I think we need this fix is also the contract is with the company. The company might have several different licensed people coming in to work on building a house. I mean, you want, and the owner isn't going to know who they're going to be. They're just going to have signed that contract with Ottaquiche Plumbing, for example. And you might have a heating technician come in. You might have a plumber come in to do the bathrooms. You might have a heating tech and they're not going to be, one assumes that they're all licensed and certified, but actually that needs to be clarified. And I think also, Matt, that we should have a cross reference. It's striking me that this registration should also have a cross reference and link into the licensed community so that people can also check who's licensed.
So it sounds to me like you're concerned, Matt, that people could spend $250 on a registration certificate and $500 on insurance, and then they could possibly be in a better position to compete with your licensed companies. And I'm not sure that that's much different than someone who's totally unregistered now can compete with your thing. It's
Mike,
they should be you're saying under Vermont law they should be certified if they're going to do this kind of work.
Licensed.
We're licensed, and so that I think should be made somehow. We need to make sure that that's clear and we're not undermining that.
I think Matt had another thought on that, though. Did you, Matt? Your hand?
my concern is less the competition. There's always going to be competition. My concern is that we're working with combustion.
Right.
We're dealing with carbon monoxide. We're dealing with flammable materials. And my concern is that someone takes advantage of this registry and cause harm to a Vermonter.
Okay. Fair enough. I mean, it almost sounds like you would rather see certification or licensure for these fields, which I think we already in some ways have. But, we try and do the light touch here. So I think there's got to be a way to work this out, but we'll have Lauren in tomorrow morning and hopefully you can talk to her during the day and maybe come back with a solution that works for both of you. Okay.
Okay.
Good. Thank you. All right, we're 10 minutes before going on to the floor, so we'll give folks a break here. Anything more before we go off Zoom live?
No, I think this is good. I think we're teed up for H157.
Okay.
Great.
Thank you.
Thank you very much. See you on the floor.
Have a good day, everyone.
Yep. Thank you, Chris. Thank